record it. There we go.
This meeting is being recorded.
Okay.
No worries. Well, thanks, Ramo, and thanks, James, for organising. James indicated, I'm a partner at Hicks Oakley Chester Williams. We're a full-service law firm. We've got about 60 to 70 staff. One of our biggest areas is wills and estates. And that covers anything from court-appointed independent administration appointments where families don't get along, through to estate planning, complex estate planning, deceased estate administration, and also a lot of estate litigation. So I suppose we see what happens when things aren't done right and where things go wrong. So it's a broad mix, but I thought the key considerations in estate planning would be helpful for you to, so I've got a bit of a presentation, we'll just run through it. So, it's more than just having a will. There's a number of things to consider. Simple wills compared to testamentary trust wills, superannuation, binding death benefit nominations, memorandum of wishes, how they fit in regarding family trusts or inter-vivos trusts, and then enduring powers of attorney for financial and personal matters, and appointments of medical treatment decision makers. So what is a will? Will clearly sets out who you want as your executor, how your estate's to be distributed on passing, and it also deals with some particular detail, whether you might have life interests to various people. So, for example, you might have a life interest in a house to someone, so they can live there for their lifetime. That may be separate to, say, like a right to reside, where different connotations attached to the life interest, where with a life interest, someone would have a right to income. It also deals with the general estate administration and what sort of directions are provided there to your executor and how things are to be. Wills can be formally executed. They really need to have 2 witnesses. There are wills that go through that aren't formally made, and as an informal will, but that often means more complicated applications to the court following someone's passing. So a formal will is much easier to deal with and less costly on one's passing. I suppose the situation is what happens if you don't have a will, and previously the legislation until a few years ago effectively said the first 100,000 and 1/3 of your estate would go to the spouse, and the remaining 2/3 of your estate would go to your kids. So that made things quite complicated, even where you had children from, just as husband and wife, and you had kids together. That made it quite messy in the event one person passed away and the house was in that person's name. Next minute, the children were entitled to a portion of the property. That's now subsequently been amended, effectively saying if there's children from a relationship and there are, and it will all go to everything will go to the partner. If there's children from children in general, whether they're from a previous relationship or from current relationship, the first 486,000 and the personal effects and 50% of the balance of the estate would go to the partner, and children, whether they be children of a previous relationship or of the current relationship, they would receive the other 50% of the balance. So that's what happens. And people think, well, if I die without a will, does it all then go to the state, Victoria? Well, the answer is no, but it can in the end if relatives can't be determined. One of the important things is with having a will and not having a will is the role of executor. So the executor is the person who effectively deals with your estate. That role vests from date of death, and the ability to go and organise the funeral and deal with things where there's no will. There is no one automatically entitled to make those decisions until a grant of letters of administration is obtained. So it can be sometimes a bit of an issue where it might take a couple of months to get a grant of letters of administration, and in the meantime there's no one actively having the authority to be able to deal with some things that pop up from time to time. And sometimes it just makes it a little bit more difficult to deal with. So key things to look at: who are the executors, who are the trustees, do they get on well with, and the choice of executors and trustees, do they get along well together? If you have multiple executors, you can have up to 4. We'd really advise against having at 4. Sometimes it can make it a bit messy, but sometimes there's situations where that is required. How are they going to deal with if they're holding money on trust for, say, minor children? Are they going to be able to deal with, say, the parental guardian of those children? How well is that relationship going to work? Should anyone be excluded? There's certain people you need to provide for under the legislation. Yes, you can make a will and leave it to whoever you want, but then also you need to provide for certain people, and they are really spouses, children. Stepchildren can have a claim as well. When you're setting out who those beneficiaries are, have you made provision for the provision you've made for them? Is that adequate and proper given the circumstances surrounding your relationship? It's not a clear cut, I've got to give them X amount, but it looks at a number of factors, and those matters really turn on their facts. Assets, are they owned? Are you you can't dispose of assets that aren't in your personal name. So sometimes people say, well, I own the shares in my company, but I want to give the assets in the company. Well, you can only give the shares in your company, which then would mean the asset. So looking at assets that are solely owned, jointly owned, often properties put as joint tenants. That means it won't form part of the estate on the death of the first of you. It will automatically go to the second, to the surviving person. Tenants in common, either in equal shares or as a distinct portion, say 70-30, that would entitle the person the will maker to leave their percentage share in accordance with their will. Otherwise, when it comes to joint tenants, it's really only on the death of the second person that asset would form part of that person's will. Family trust assets are separate. Superannuation is also separate, but superannuation may form part of your estate, and I'll come to that later. So, like we mentioned, estate assets, non-estate assets. Superannuation, if it's paid to the estate via a binding death benefit nomination, could then be held in accordance with the will. If you want it to go to someone who's effectively not a dependent under the superannuation law, that's the only way it can go to a non-dependent, is the nomination has to be made to the estate, and then the estate dictates, or the will then dictates where it goes. Standard simple wills, they may be typical husband to wife, wife to husband, then to the kids equally at a certain age, where it's held in trust until they attain a certain age. There's also wills that incorporate, I mentioned earlier, touched on life interests or rights to reside in property. wills that set up a protective trust. For example, someone might have an addiction, and it might need to be protected from themselves, so they don't go and blow it all. And then we've got testamentary trust wills, which they effectively incorporate like a discretionary family trust deed. And there's really two major advantages of those trusts. One is asset protection. So it gives the way we set them up gives the option for the beneficiary to choose as to what assets go into that trust from your estate. But whatever goes in there is protected from creditors. So it gives that advantage of asset protection. So someone who is to receive an inheritance, if they were, say, running a business and you're concerned they will get this possibility of losing those assets in the future, you can put them in. If the assets go into the testamentary trust, they'd be protected from creditors. And the other major advantage is tax minimisation and being able to distribute the income from the assets in the trust to minors, and getting the adult marginal tax rates for minors, which into Vivos family trust that's set up, you can only distribute a small amount to minors each year before being taxed at penalty rates. So we've got estates where grandparents might have set up a testamentary trust as part of their will. They've given the benefit for each of their children to have that in place, and those children now then pay part or most of their kids' private school fees directly from the testamentary trust, and rather than them paying tax at their own personal rate and then paying the school fees, it's a way of them saving tax as a family unit.
So such a trust can, instead of paying an income to the person, they can actually pay off debts or fees and things like that of the beneficiaries.
It's effectively distribution to those beneficiaries, and fees. Say, for example, school fees be paid from that distribution. The money doesn't have to effectively go directly to the child. It's deemed as a distribution to the child.
Okay.
So the way those are set up, they depend on the circumstances. Typically, it's the appointer who holds ultimate control, and they've got the ability to change who the trustee is. But they are a very effective tax planning, tax effective mechanism, which if you do have assets that, the way we set them up, we give the flexibility for the beneficiary to choose on death as to whether they take them up. You can make them compulsory, but given tax laws may change, we give the option to, so you're not locking them in, you're giving that flexibility to your beneficiaries as to whether they want to take them up or not. So for example, one child might say I'll set it up, and the other child might say I'm not. So they're not. So kids might not be tied to each other; they have their own separate trust. So it gives that flexibility. Okay. So how often should you review your will? Really, when marriage, separation, divorce, big events, birth of a new child, changes of assets, how they're held. It may not be that the beneficiaries need to change. It might be the control of, say, a family trust. You might say, I want a sibling to control a family trust that's set up, and it might be, if you don't specifically look at the trust deed, the default control from that family trust might go to your executor. So it may be that you need a separate clause in your will or an amendment to the trust deed saying that on my death, the appointer role passes to whoever. So lot of time, you can change a will by making a new will or a codicil. Codicil effectively more done when the age of typewriters, and if you didn't have to retype the whole document. Now it's just easy to make a new will.
Yeah.
Memorandum of wishes. This is a separate document you may wish to put in place if you've got a family trust that's been established. You may wish to give not a binding direction, but a sort of a wish list as to how you want that trust to run. And you also, sometimes people in memorandum of wishes put in how they want their children to be looked after. So that's something that people can always have as it sort of sits to the side of the will, or but gives some guidance to the people you're putting your trust in. Super death benefits. Very important to make sure you've got the correct nominations in place. I hear of circumstances where no binding people may have separated in their relationship. Next minute, one's passed away, but they haven't changed the nomination, or they've changed the nomination and they nominate the child to receive the benefit. And effectively, what happens is then the ex-partner has control over the death benefit while their child is a minor, often there's situations where that occurs, where people obviously aren't happy with that situation. The way to deal with that is then to make sure the nomination's up to date, nominates your legal personal representative, which is effectively the executor of your will, to then the benefit goes into the estate and then can be held upon trust in the estate for a minor until they turn a particular age. Without that binding nomination, the trustee of the fund has the discretion as to determine how it will be paid. So whether it's a industry fund, whether it's a self-managed fund, you're leaving the discretion up to someone else. So it's important that you have them in place. Like I mentioned earlier, super can go to dependents, such as spouse or children, and or the estate. And there's different tax treatment relating depending on how old your children are. So spouses and children under 18 receive the death benefit tax-free. Children who are still financially dependent between 18 and 25 can receive it tax-free. But once they're over 25, there is death benefits tax on the fund, and on the taxable element in the fund, it's 15% plus Medicare, and on the untaxable element in the fund, it's 30%. So there are ways of making sure someone who can receive it in a tax-free environment receives that.
Lockie, I think there's a question.
Oh, sorry.
Raj, have you got a question?
Oh, yeah, quick question, Lachlan. Sorry. So this also can be added as part of the will, is it? So we can, yeah?
Well, no, it depends. It'll be, if it's a self-managed fund, you do a separate document, binding death benefit nomination.
Yeah.
If it's like an industry fund, you'd have to, it depends on the terms of the trust deed of each particular fund, but you'd have to typically go to their website. They'd have a non-lapsing binding nomination form, or a binding nomination form, and you can fill it out. What I'm saying now is some of the funds are allowing you to put a preferred beneficiary nomination on your fund. And that's done just on the website.
Yeah.
What you must realise is that's not actually a binding death benefit nomination. It's just that it's effectively deemed as a non-binding nomination, and it's still giving the discretion to the trustee on your death as to where they pay the benefit.
Right.
So for it to be, I think under the superannuation law, it needs to be in writing and have 2 witnesses. So you really need to print out the form, complete it with 2 witnesses, and send it back by post.
Lachlan, the other thing is in some of the industry funds, even a binding nomination seemed to only last 3 years, and it has to be renewed every 3 years.
Yeah, and that's right. Yeah,
Yeah.
and that's what, and so that's something that is an issue with a lot of the funds, and you just have to do that every 3 years. Some of them now are moving to having non-lapsing binding nominations. But that they have to update their deed to be able to do that. So yeah, look, if I get a deed that comes across my desk, and if it's a self-managed fund and it only allows them to be renewed every 3 years, I make them update the deed so that they can put in non-lapsing binding nominations, so they don't have to worry about that 3 year.
Yeah.
3 year limitation.
Thanks, Lachlan.
Other issues that should consider in estate planning. So will comes into effect on death. Powers of attorney operate while you're alive. In putting in place an enduring power of attorney for both financial matters and or personal matters. So financial matters is dealing with issues such as property, super fund, day-to-day paying bills. So just say you had an accident or illness. Without this document, no one can sign on your behalf without having without the document. They'd have to go off to VCAT, the Victorian Civil and Administrative Tribunal, and be appointed your administrator. So administration order would be for financial matters in effect, and you'd have to get a guardianship order really for personal matters. So you can save the hassle. So everyone thinks, oh, well, I'm not, they do their estate plan. Oh, I don't need a power of attorney until I'm old, until I'm going to be demented. But people don't know when you're ever going to have an accident or when you're going to ever become unwell, and then you can't sign. I've had situations where husband and wife married 40 years, all the bank accounts are in his name. She can't access no power of attorney in place. She can't access, she's got no funds to spend, to do anything or pay any bills with. She has to go off to get an administration order, and then she's got to wait 8 to 10 weeks for a VCAT date and a hearing. So they could have made a simple power of attorney, and she would have had the authority to be able to access the accounts. Personal matters are those, lifestyle decisions. If you need to go into care, where you're going to go, who can visit you, things like that. So I always recommend that everyone at least has an enduring power of attorney for financial matters, just so that they are covered. So even if you might have, just for example, people often have property, husband and wife have a property in joint names, it's mortgaged. The spouse can't even sign the new mortgage documentation, or even if someone got ill, or they can't sell the property. So it's just something that everyone really should have in place. And then the other downside with going to VCAT, then you've got to report to VCAT every 12 months as to what you've done with your assets. So effectively, you're making hard work for yourself in the long term. The other document that sits alongside, so this is the appointment of medical treatment decision maker. It was previously called an enduring power of attorney for medical treatment decisions. It allows you to appoint someone to make medical decisions where you can't yourself. You can appoint up to 4 people in a descending order. Where that differs from the financial and personal power of attorney, under the financial and personal, you can have a mixture of people. You can have people jointly, you can have people jointly and severally. So any one of them listed can either do it together or separately, or you can have a majority. So it's quite flexible for the financial and personal matters, but for medical, you have to pick an order. What also sits alongside that is an advanced care directive, which hospitals used to have their own sort of advanced care plan people could put in place if they are unwell. Now this has been replaced where you can actually bind your medical decision maker to make legally binding instructions. So you might say, for example, if I'm on life support, I don't want to be resuscitated, and that'll bind the medical decision maker. Or you could have a values directives in there, which is, for example, if someone's particularly religious and they wanted to certain things to be abided by, that could be in the values part of the advanced care directive. And that's about all on the sort of the key considerations. Happy to take any questions or.
Thanks,
I
Lachlan.
think that sort of gives a general understanding of what documents are required for estate planning and things like that. I think my thoughts are we'll distribute this recording to everybody, and they can go through that at their own time, and then they can come back to you. I think an indication of what it would cost for a general standard will, as well as what a general cost estimate for a testimonial trust will, would probably be beneficial.
Yeah, no worries. I've got a cost guide, which what's the best way of circulating?
If you can email it to me, I'll distribute that to everybody.
Yeah, no worries. Yep.
James has got my email address, so you can send it to me, and then I'll send it to everybody else.
Yeah, sure. So it varies, like sort of packaged up, but I think they're fairly reasonable.
Thanks, Lucky. Any other questions for Lucky? No. Switch off your share screen there now. Now, I haven't got a presentation as such to go through. I was just going to kind of talk through some basic topics and process and things that we tend to follow on the estate planning side. Sorry, on the financial planning side of things and what that looks like. So maybe just the two typical types of clients that I work with, if we maybe start there. So I do a lot of work with high income families. They're often late 30s, early 40s, through to late 40s. Household incomes $300,000, $400,000, $500,000 plus, a couple of kids, they've got a house with a mortgage, and things are pretty comfortable, but they're all getting to this point as to say, well, what next? They all come to me with this question of what next? What do we do next? We've bought the house, maybe we've bought an investment property. I know a little bit about super, but what should we be doing next? Ultimately, with this view to heading towards retirement, often wanting to set up some investments and things to help give their kids a little bit of a head start when the time is right for them, whether it's a deposit for a house or something like that. So there's these high income families that I tend to work with. And then the other group of clients that I work with is what I refer to as retirees. They may very well have reached out to me and say, hey, James, I retired yesterday. I've got the assets that I've got. Help me make best use of those to support my retirement years. Or like the phone call I had with someone just a little bit earlier this morning, they're looking at about 5 years. They're saying, you know what, we've got some assets. By the time we get to 60 or 65, which might be 5 years away from now, we're wanting to be in a position where we can start to wind down work. More and more I'm seeing from people this idea of not necessarily, at least today anyway, aspiring to getting to a point in time where they just stop work altogether, but wanting to wind back in some way, work part-time, but get to this kind of flexibility, this financial flexibility stage where they don't have to work 5 days a week, bring in quite the income that they currently are, and they can start to wind that back a little bit. So they're the two types of clients that I tend to work with. And then the elements that we work through, and this is kind of starts to get into some of the detail and Rama, the points that you sent through this morning, kind of get to those too. So there's 5 elements that we work through. So the first one is cash flow. So just making sure you've got some type of structure for capturing and identifying what's coming in versus what's going out. I'm not a big advocate for you need to track every single cent and record that you bought a coffee and you did this and you did that and all the rest of it. But just having some structure to identify what's going in and what's going out but making sure that lines up with what it is that you're wanting to achieve in your own life. Some advice that I delivered to a new client a couple of weeks ago. One of the big things that they wanted to do is in 2026, they wanted to take their family on an overseas holiday. We estimated that it was going to cost them about $50,000, the things that they wanted to do. And so in the cash flow piece of the advice to them is to say, well, you're planning on spending $50,000 in a few years' time. Let's work that back into monthly installments. How much do you need to be setting aside over here to help fund that holiday? There's no point investing that into shares or property or doing anything more adventurous with it. We know there's a deadline in June 2026. You want to take the family overseas on a holiday, and so what's it going to cost? And so some structure around cash flow, as I said, to identify what's coming in, what's going out, and helping that line up with the things that you're wanting to achieve. The next element that we look at, the second part, is debts. So do you have a debt on your own home? Do you have an investment property? These kind of things. Understanding what interest rate you've got. Is it principal and interest? Is it fixed? Is it variable? Is it interest only? All of these different elements. Are you using offset accounts and all the rest of it? So making sure whatever debt structure you have in place is set up appropriately to help you achieve the things that you're wanting to achieve in your life. I talk to younger people that have this aspiration of they've bought their first home, they want to keep that and then upgrade to a bigger place when they've got a family and things, and keep the original house as an investment property. If that's an aspiration, it doesn't make a whole lot of sense to be putting money into the mortgage and actually paying off the mortgage on the first house. It doesn't work for tax purposes. What's a better strategy is putting money into an offset account and building up an offset account that you can then take that cash to then put towards buying the bigger property. So some conversation around debt, and make sure that you are managing your debt in an appropriate way. Then there's also paying it off over a period of time so that you can retire debt free. The third element is protections. So this is really just looking at insurances. Life insurance, total disability insurance, both of which most people will have some amount of cover through their super funds. There's often a default level of cover through their super funds. Is it enough? Is it too much? Is it expensive versus what you can get elsewhere? There's answering all of these questions. So there's the life and the disability insurance, income protection, which covers your income. Now the world of income protection insurance changed a year or so ago. You can't get quite as generous policies now as what you once were. That whole income protection market was
James, and there is no more agreed value policies anymore.
Yeah.
Isn't it? So if somebody's got them, they shouldn't cancel them.
That's it. So no more agreed policies. You also can't get, there were some policies where you could protect 80% of your income right through until age 65. Those types of things don't exist either. There's often steps. So if you're on a long-term claim, some policies might drop down to 50% of your income after a couple of years. That was all to do with income protection was just unprofitable. So these insurances need to run at a profit so that the companies offer them in the market. But the terms and conditions around income protection had become so generous that it was unprofitable, and all these insurance companies were actually at the risk of going under if something didn't happen. So there's some big scale back on income protection. But Rama, as you said, if you do have one of these older policies, you can't get them anymore. So you want to look at trying to keep that. The downside is that the insurance companies know you can't replace that anymore. So they increase the premiums significantly year after year after year. So they're going to become frightfully expensive over time. The fourth element is around succession. So that's really what Lachie was just talking about. My involvement in that is just helping clients identify what have they got, who are the important people in their life, what do they want to happen with their assets, and so forth. And then we link in with Lachie to do the documentation around all of that and facilitate a little bit more of an in-depth conversation. As Lachie was talking about, he had a slide there around superannuation. So part of the research that we do into when we're working with new clients is we is we call your super fund and find out, what's your balance, what's your investment option, what's the fee structure, do you have a beneficiary nominated, all of these kind of things, and we'll be highlighting to clients to say, you've got a beneficiary, or a really common one for young people is that they'll nominate their parents as beneficiary. As that young person gets older and buys their own house and so forth, their parents are no longer CIS dependents, and so you can't actually pay. Like for me, for example, I can't pay my super benefits to my parents on a beneficiary nomination. So if I still had the same nomination from when I was 15 years old and had my first part-time job, it's not going to work. So that kind of thing needs reviewing. And then the fifth element, and this is often where people kind of think they're starting when they reach out to work with me or another financial advisor, is this whole investing, structuring type journey. So there's a minimizing tax element to it. There's a building up of assets, using super and so forth in all of that. So that the advice and what that looks like is going to differ from one client to another, but in most cases it's some combination of paying down your debts over a period of time, topping up super, particularly for higher income earners. There's a big tax saving to be had by putting money into super, possibly buying investment properties for the negative gearing benefits, and growing assets over time if someone hasn't already done that, and then regularly investing into the share market. So some combination of all of those elements, but putting some structure and some rigor and some purpose around all of that to help you get to these, whatever it is that you're aspiring to get to. The phone call that I had with someone this morning, he's 55, wanting to get to, by the time he's 60, a position where he's got enough assets to support an income of $100,000 a year in retirement. So the back of the envelope calculation for him that we tend to use is 20 times. Multiply whatever it is that you think you want to live off in retirement by 20. That's roughly going to be the level of capital that you'll need to fund that. So for him, between himself and his wife, they've got about $1.2 million worth of assets right now outside their home. They need to try and get that up to about $2 million over the next 5 years, and we'll put some plans and stuff in place to help them get there. So that's kind of a brief intro into the financial planning side of things. There's some detail around superannuation and trusts and companies and all the rest of it, but if anyone's got any particular questions around that, I can go into it. But that's the brief intro into the financial planning side of things.
Thanks, James. Again, since you touched on the shares thing, so most of us here would know what share is, but we don't know where to invest in. I don't know what kind of guidance you can provide in the share market. So is it something, there's guidance from your end as well while following share on the share market?
Yeah, absolutely. So part of the way I tend to describe it, there tends to be two elements to the financial advice. There's a structure piece at the top, which is debts, super, trust companies, your name, your wife's name, kids, all of these kind of things. So there's a structural element to it. And then the next level down is the investment element to it. So we have a particular philosophy that we follow around how we recommend that people should invest their money. We call it circumstance and attitude. So your circumstance is things like, how old are you? How much money, how much capital do you have behind you? What level of income do you need from that capital to support your lifestyle? Most people that are working, the answer to that's zero. They go to work and that's what provides their income for their lifestyle, not so much from their assets. So there's a circumstance element to it. And then there's a second part, which is what we call your attitudes. So that's looking at how comfortable are you with the ups and downs of share markets? And there's a whole series of questions that we go through with that, ultimately to get to something that we call an asset allocation. So it's this mix of assets between what's on the more defensive, conservative side versus what's on the more aggressive growth side. Do I think you're comfortable with as an individual? And then we make recommendations filling it in around that. So it might be a certain amount in the Australian share market, a certain amount overseas, a certain amount into property trusts and so forth. But yeah, it gets, for those that want that level of detail, it gets down into that. The best outcome, though, as part of this kind of wealth building exercise, if you're investing into the share market is part of that, the best way to go about it is to try and identify what amount of money can you contribute towards this on a monthly basis. Just make it regular. You want to take the thinking about the share market away from it as much as you can. So if it's $1,000 a month, okay, well, what's the split of how we're going to invest this $1,000, and then just month after month after month after month, just invest it so that you get these longer term compound returns that you want to try and get over time, rather than saving up $10,000 and then trying to pick a stock and then trying to save up another $10,000 and trying to pick another stock. That it doesn't work. Very rarely does that ever work. It's much better for you to put $500 a month or $1,000 a month or whatever it is into super and just into the share market and just do it month after month.
The other thing too, James, is one of the things that James, can you hear me?
Yeah, I got you. Yep.
Yeah. One of the things that I've sort of noticed from talking to a lot of our friends is that we sort of contribute to super very, very passively and don't look at super at all, especially when they're in the younger age. We just the employee puts in 10% and that's it. I won't even look at it. People don't even know how much super they've got, whether they've got insurance and super or not, because even annual statement comes in, people don't open them. They think that's we'll wait till retirement and we'll look at what's there and then we'll figure it out. Yeah. And one of the things that I'm feeling that people need to sort of actively look at is a super strategy. Yeah. So that they're working out if maximizing super is their way to go. What are they doing? Are they doing consensual contribution, non-consensual contribution, this downsizer, all that sort of stuff as a active, structured process rather than cross your fingers and hope we'll get there at the end.
Yeah, perfect. So look, in terms of super, and Balal's asked a question about trusts and companies and stuff. I'll come back to that question in a second. So super. You need to separate super from the ups and downs of share markets. And for the moment, just think about it as a tax structure. There is no other structure available in Australia where you'll pay as little tax as what you do on superannuation. The easiest way for me to explain this, I'll do a whiteboard here and hopefully you can all see it. This is the diagram that we do when we're talking about super. So if you think of super as a bucket for a moment, this isn't about BHP shares or Telstra shares or property or anything like that. This is about the tax structure and the tax environment. So money goes into super in one of two ways: as part of your wages, or you can put some of your own money in. I'll just do an O for own money. So if you had money in your bank account, for example, you can put some of your own money into super. As part of your wages as an employee, or if you're self-employed, you can do these types of contributions. On this side, there's an annual limit of $27,500 can go into super on this side. When that money goes into super, it's taxed at 15%. If you earn more than $250,000 a year, it'll be taxed at 30%. But it's, for most people, it's far less tax is payable on this income when you tip it into super than if you took that money as a wage. So if you were earning more than $250,000, for example, you're going to pay top marginal tax rates, you're going to pay Medicare levy, all the rest of it. You're paying the best part of 47, I think it is 48% tax to take that money as a wage in your pocket, versus putting it into super, you'll pay a much lower rate of tax. Your own money over here on the right-hand side, if you had some cash in the bank and you wanted to put that into super, there's no tax payable on putting that money into super. That's just acknowledging the fact that for you to have money in your bank account in the first place, you have already had to have paid tax on it somewhere along the lines anyway. So you can put some of your own money in. On this side, there's annual limits of $110,000, or you can group together the current year plus the next couple of financial years and put in up to $330,000 in one go. Now, so getting money into super, particularly if it's on this left-hand side, is incredibly tax advantaged. There are some rules available, these things called catch-up concessional contributions, where if you have less than 500,000 in super, you can go back and use up unused contribution caps from the last few years. As far as this will eventually be a rolling 5-year thing. We're at year 4 at the moment. What this means is for someone that hasn't put in any money, if you hadn't put in any money, for example, if I just cross this out, you could put in for this current year 102,500 and claim all of that as a tax deduction. So I've done some advice for someone exactly like this, a single lady that for various reasons hasn't worked for a number of years, but sold an investment property. She's made the best part of about a $500,000 gain on that property. She's able to use these catch-up rules and put in $102,500 into super and claim the whole lot as a tax deduction, which significantly reduces her tax bills. So anyway, you get money into super whilst it's in there and it's in this, what's called the accumulation phase. So you're building the balance up. Any earnings on your money are only taxed at a maximum rate of 15%. So far less tax than what you would pay if you own shares in your own name, if you bought a property in your own name, all of these kind of things. And then the holy grail of super is when you get to retirement age and you draw a pension. So for most people now, this is age 60, depends on your date of birth, but for most people, it's age 60. Once you're over the age of 60 and you're retired, two things happen. You take money out of here and it's no tax. So you start to live off your super balance. You don't pay any tax on taking this money out if you're over the age of 60. And then two, this tax rate here goes to zero on the first 1.7 million of assets that you have. Now, if you've got a partner, your partner can also have $1.7 million. So you could have between husband and wife $3.4 million worth of assets inside of the tax structure of superannuation, not pay any tax on rent, no tax on dividends, no tax on capital gains, no tax whatsoever on up to $3.4 million of assets if it was evenly spread between you and your partner, and both of you drawing a tax-free income down here. So as I get to the kind of intro to this part, there is no other structure available in Australia where you pay no tax at all. The only one is super. The downside is that for most people, you can't access it until you're age 60. So if you put every single spare cent you had into super and you're only 45, or you can't touch it for a long while, you need to give some consideration to that. And two, there's, in the scheme of things, relatively small contribution amounts that you can put in annually. These two amounts here, you can't dump $1 million into super tomorrow morning. Those types of limits don't exist anymore. So that's the superstructure part, this first element, and then the next part is around how are you going to invest that, whether it's shares, whether it's property, whatever. You can invest into all of those kind of things and just have the advantage of the tax rates that come with the superstructure. All right, so that's super 101. There's just a couple of questions here. Rama, you spoke, is the downsizer age reduced from 60 to 55 that both goals are proposed? Yeah, so yeah, I guess in addition to those contribution limits that I was just talking about there, over and above that, there's some downsizing rules. So the downsizing rules say, at least at the moment, from July. So this is from July. If you're over the age of 60, you've owned your own home for more than 10 years. So you don't have to have lived in it for that whole 10-year period, but you've lived in it at some point. You get the technicalities of it is you get a partial CGT exemption on the sale of your house. So over 60, own the house for more than 10 years. If you sell it, you can then put $300,000 into super over and above any other limits that exist. And if your partner's involved as well, it's $300,000 for them as well. So you could put $600,000 into super. The age limit is currently 60. Both sides of government proposed to reduce that to age 55, but it's not yet 55. That's some further legislation that would need to pass the whole process to adjust that age. It is, as I'm speaking today, it's 65. On the 1st of July, it will be age 60. And then there's a possibility of that dropping even lower to age 55. Can allocated pension fund include assets like property, liquid cash funds, available managed funds? Yeah, absolutely. So in that super bucket diagram that I was just drawing there, you can, depending on what type of superannuation fund you are using, if you had a self-managed super fund, which is the one that gives you the most level of flexibility, you can just about invest in anything that you want. Shares, cash, property, commercial businesses, commercial premises. So if, for example, you run your own business and you rent an office somewhere or you rent a factory somewhere, you could buy your own factory or your own office in your self-managed super fund and rent it from yourself. So
but then how do you forcefully get that 5% every year out? So if it's a property, and then like let's say you've got a property and it's worth $1 million, but it's not returning 5% return.
Yep.
And how do you forcefully take that 5% out every year?
Yeah, so that's the challenge with just having property. The downside with property, I'm just on a call. The downside with property is the downside with property is that you don't earn much in the way of rent. So property is fantastic for helping build your assets up with the leverage that you get from borrowing money from the bank and all the rest of it. Property, unless you've got millions and millions and millions of dollars of it, is not great for funding retirement, because you'll get 2 or 3% rent if you're lucky from your property. The minimum pension requirements, at least between 60 and 65, is 4%. Over 65, it goes to 5%. So you can end up in this position where the minimum pension requirements are far higher than the rent that you're actually earning, and you end up having to sell the property.
Yeah, okay.
So you combat that one of two ways. You either sell the property, or you own a property and enough other liquid assets that you can slowly run down the other liquid assets to then eventually sell the property later down the track.
Okay.
There was an earlier question about, can you give a brief overview of buying property under a company trust other than buying individually, benefits and risks? So the thing to consider around a company when you're buying an asset, whether it's shares or property, a company doesn't get the 50% capital gains tax exemption on the sale of that asset. So a company that is passive, that only owns shares and property, it's more an investment type company, that'll pay tax at 30%. There is no concession for owning those assets for more than 12 months like an individual gets. So the capital gains tax rate that an individual will pay if they've owned the asset for more than 12 months is a maximum of 24%, something like that, whereas a company will pay higher. The trust itself doesn't pay tax. It has to distribute its income and capital gains out to beneficiaries, and then the beneficiaries pay accordingly. So if the trust is distributing out to an individual, you get the 50% concession. If it's paying out to a company, the company doesn't get the 50% concession, so it's stuck with the 30% tax rate. The other thing to be aware of is land tax is a big consideration. So a trust doesn't get the land tax concessions like an individual does. So if you went and bought an investment property, and I think the amount differs in different states. Lockie, you might be across that a bit more than I am, possibly. But the land tax, you get, your own home is exempt from land tax, but then for investment purposes, there's a threshold under which you don't have to pay land tax. In a trust, that doesn't exist. So you'll often have much higher land tax bills payable in trusts and companies than you will in your own name. Lockie, I guess in terms of estate planning, I guess the thing to consider there is that, circling back to what Lockie was talking about, is you don't actually own those assets. So if you bought a property in a trust, you might control the trust, but you don't own the asset. So in your will, you can only pass on control of that trust. Or if it's owned in a company, you can only pass on the shares in the company that you own to your beneficiaries, and then they'll choose to do what they want from there. Lockie, anything else that you would add around property and trust and companies?
Not really. I suppose it's around the asset protection. If you're running a business separately yourself and you want those assets to be protected from, if you ever got sued from a creditor or something like that, at least they will be protected, I suppose, if they're in the trust, won't they?
Yeah, that's it. So there's advantages and disadvantages to it. There's not going to be any blanket rule about you would do this or you wouldn't do that. It's going to be taken on each individual set of circumstances. But yeah, the asset protection part is a big advantage of doing it via
James,
the
do you
trust.
also help people with self-managed super funds if they wanted to just set something up like that? Is
Yeah,
that something you help with?
Yeah, absolutely. So First Financial, we do tax returns for about 550 self-managed super funds each year. Some of those are done internally. Some of those are done. So some of those are clients of First Financial from a financial planning perspective, and some of them just use our accounting services for the tax returns. We do, but there's a big emphasis on why are you setting up the self-managed super fund.
Yep.
You know, it's not just a blanket, I want a self-managed super
Yep.
fund. What is it about the self-managed super fund that attracts you to it? And can you get that elsewhere without all the risk and complexity and everything else that goes with operating a self-managed super fund? Because they're complicated vehicles, and you're ultimately liable for what's going on there.
The last question I sort of asked there about the downsizer timing is that we've got several people in the group where they've lived in a house for a period of time, but they've actually moved on to another house and rented out the house that they originally lived in. So technically, if they have, is there a period of time or a specified period of time during which you have to have lived in that house to be able to claim the downsizer, or it doesn't really matter?
No, there isn't. So the only requirement is that you have to be able to claim at least a partial CGT exemption for being your residence. So say, for example, you've owned a property for 20 years.
Yeah.
You lived there for the first 5 years, and then you've rented it out for the subsequent 15 years. When you go to sell that property, you would claim a partial capital gains exemption for living in there for a period of time. That's fine. You'll tick the box.
Yeah.
So long as you're over 60, you can claim a partial or a full. At least you have to be at least a partial exemption from capital gains tax. Okay. Because you lived there. Then that's
even
fine.
if it was months or years, there is no specified period of time for which. And how do you, what documents would you need to show them that it was a principal place?
So you need to do, so there's a fairly strict time period around this. So you have 90 days
after selling.
You have 90 days from the settlement of the property to make the contribution. So it needs to happen fairly quickly. And then there's a particular ATO form, a downsizing contribution form from the ATO that you need to provide to your super fund at the time that you're making the contribution.
Do you need to sort of keep documents like, it was that you had addresses in there, or whether you had utility bills in there and things like that, or is it just a declaration?
No, it more comes back to your tax return. So the ATO will see, so your super fund has your tax file number. And your super fund, when they do the annual reporting at the end of the year for your super fund, they'll report to the ATO that you've made a contribution, you've claimed it as a downsizer. That's tagged to your tax file number. Then when you're doing your tax return as an individual, the sale of the property also flows through your tax return, and they'll match it up that way. So there's a question here. What happens if the property is held on joint names? Do we need to wait for both to turn 60 for the downsizer benefit? So you don't, if you want to use the downsizer rules, you both have to be over the age of 60, but there are other rules, which I was just had on that share screen that I had before, where you can still make a $330,000 non-concessional contribution to superannuation within the contribution caps. So you can still get money into super, you just can't use the downsizing rule to do it. There's other contribution limits that you can.
Just 1 second, James.
You're right. Any other questions? I don't want to keep you all for too long, but any other questions, if you want to drop them in the chat or say it out loud for either of us. No.
Probably I'll ask one other question.
Sorry about that. Somebody was at the door.
Yeah, I'll continue. I'll ask one question probably. As already Rama mentioned, the people are living in a primary place of residence and moved out to a rental property or any property, and still the primary place of residence. Usually the primary place of residence get an exemption from paying a land tax. I think since I moved out of my own property and I'm renting out somewhere else, so should I pay land tax for that property, or should I keep it as a primary place of, because usually they give exemption for the primary place of residence. So how to handle this?
Yeah, they'll eventually cap. So if you've moved out and you're renting it out, it would start to count as land tax. So there's some. They'll eventually catch up with you if it's not you. I think it's the State Revenue Office. I think is where you adjust that.
Yep.
But they'll, yeah, if you haven't reported it, you'll be able to get away with it for a while. But after you've lodged some tax returns and you've got rental income and so forth in there, they'll work out what's going on, and they'll eventually send you a bill for land tax. So you probably want to get onto it before you end up having a big bill to deal with.
Okay. So we should intimate them to be converted as an investment property, is it?
Yeah.
Because the idea is still I'm planning to go back after some time to the same property. So that's the intention. So I'm not sure whether should I convert it to primary place of residence, from primary place of residence, or investment property. Yeah.
So there's you can keep it as a primary place of residence for tax purposes, or for when you eventually sell it at some point in the future. There's a rule that allows you to move out and still treat it as your primary residence. But I don't think the same applies on the land tax side of things. I think it's once you've moved out and you've started renting it, you've then got land tax payable. Best to check with your accountant on that, but I think you'll be up for land tax straight away.
Okay. Excellent. Thanks for that.
Okay. So from here, James, like if you send me a link to the recorded thing, as I'll send it to everybody else so they can look at that. And then I'll probably pass on your contact details and Lachlan's contact details to the group. And would they then maybe perhaps do a one-on-one with you, like a 15-minute, half-an-hour session to see suitability, and then take it from there and then work out fee structure and things like that? Is that
absolutely? Yep. So if anyone wanted to take things any further, I mentioned Lachlan, you probably work the same way. We'll have a phone call, some type of introductory conversation with you, just to see if we can help, if you're interested, that kind of thing. And then we can talk about next steps and fees and things if you did want to take things any further. So
do you do both things, like if they want to just have a fixed one-time session where they may come to you to work out their overall plan, and do you also do an annual sort of review, financial planning, financial advice, regular sort of thing as well?
So from the financial planning side of things, I guess if I'm to provide advice, I tend to describe it as a project. There's a series of a couple of meetings, doing some research, and coming back to you with some recommendations. Maybe it's just keep doing what you're doing. Maybe it's tweak this thing, tweak that thing. But regardless, I have to provide that advice in something that's called a statement of advice. There's a particular written format that has to take. Yeah. So for that type of project, it's typically something like $3,000 or $4,000 is what I typically charge for that. That can just be a one-off piece of work, and then help you sort out a few things, and then off you go and you manage it from there. And then there's other clients that would engage in an ongoing advice service, and that takes a couple of forms depending on what you're looking for. So that's from the financial planning side. Lockie, what does it working with you look like on the estate planning side?
Typically it'd be you're looking to proceed and put those documents in place. I'd have an initial meeting, take your instructions as to what you want done. We'd then send draft documents out, and then we'd get you back in to sign. So it's a bit more...
With estate planning, like one of the things that you'll find common with most of the guys in this group is that they will have assets here in Australia, but they will also have assets in India. One of the things that's always come up and confuses people is the latest will is always the valid will, is what they normally say, right? So when you create a new will today, whatever we had done before yesterday goes. And often I've heard that if you create a will in Australia, that doesn't apply in India because it doesn't have a legal standing. So if we created a will here today, and then a month down the track, if we go and create another will in India to cover the Indian assets, how do we make sure that doesn't override this? Because that probably will not talk about assets here.
So you'd make a will here. We can make it specifically say that this will only applies in relation to my assets as they apply in Australia and elsewhere other than India. And when you wouldn't or if there's an existing will in India, or there's to be a will done in India, we make sure we don't revoke any will made in India. And if you go and make a will in India, make sure it doesn't revoke the Australian will. So
there's some sort of a specific thing that we have to do to make sure that happens. Yeah.
Yeah. Rather than the will saying, I revoke all prior wills made by me, I revoke all prior wills made by me other than my will made in Australia.
Understood. Okay.
Yeah.
Okay. And the other thing is with wills and testimonial trusts and things like that. First of all, the testimonial trust, I'm assuming, only gets enacted in the case the will is executed.
That's right.
And in the case of the will, is there a filing authority where we would actually go and file the will, or do we just keep a copy of that?
Typically the will would be held by the solicitor who prepared it, because there's a presumption you've destroyed it if you lose it. Yeah. But what happens on death is you'd have to get a grant of probate of that will. That original will then goes to the Supreme Court of Victoria, gets effectively stamped by the court saying it's a valid will, and then the executors have the authority then to deal with the assets according to the will.
Okay. So there isn't like a registry where you would actually go and register a will or something?
No, you can register them with the Supreme Court, but that doesn't happen. No, there's no central wills registry.
Right. But you can register with the Supreme Court if you wanted to, is it?
That's right.
Right. Okay. Okay. So you would send me the links for the video and your profile or a briefing of file structure and things like that. I'm assuming James will do the same, and I'll sort of distribute that internally within the group, and including are you happy for me to send the video to people who initially showed interest but couldn't attend as well?
Yeah, that's fine. I'll put it up on YouTube. Send the link to whoever you want to send it to. That's fine. No dramas. Yeah.
Okay, sounds good.
All right. Thank you, everyone.
All right. Thanks.
Thanks, James.
Thanks for your time today.
Thanks, guys. Thanks for your time.
Bye.